morning, everyone. My name is Karen Shelton, as Rochelle said. I'm the Advanced Care Planning Coordinator here at Howard County General Hospital. So my role here is to actually meet with patients at the bedside who either request information about advanced directives, would like assistance completing an advanced directive, or perhaps they already have one and they just need some help getting it on file at the hospital. So I'm going to be presenting the first portion of our presentation today about advanced directives, and then I'm going to pass the baton to Alan, and he's going to take over. Okay, so let me share my screen here. All right, are we good? Everybody can see that? Okay. All right, so let's start. Whoop. Get my slides to advance here. Hold on a minute. Figures right off the bat, I'm going to have a problem here. All right, let's try this again. So what exactly is an advanced directive? An advanced directive is a document that allows you to do several things. One of the things that you can do is to name a healthcare agent. It may also include a living will. And then sometimes there's also a third section that asks about, would you be interested in being an organ donor or donating your body to medical study? Who do you want taking care of funeral arrangements? Do you have any preferences in that regard? And we'll go through each of these individually. If I can get my slides to advance. Let me stop sharing again and go back into my PowerPoint. Sorry, everybody. Michelle, any tips here?
So just don't use the presenter view if it's causing problems, and just go from slide to slide. That's fine.
Yeah, let me try to get back to it here.
If anything, you can send it to me too, and I can just click on through for you.
Sorry about that. We'll try it this way. It always works until you really need it to, and then it won't. Okay, so what is a healthcare agent? A healthcare agent is someone that you want to make healthcare decisions for you when you're unable to do it for yourself. It's also known as a durable medical power of attorney. So some examples of a time when you may not be able to make healthcare decisions for yourself are, maybe you've been brought to the hospital and you've lost consciousness for some reason, or a person who has dementia, or perhaps you've been seriously injured and you're unable to communicate for yourself, or you're seriously ill, maybe it's an end-of-life situation. So a healthcare agent is not a financial power of attorney. A healthcare agent is responsible for making healthcare decisions only. It does not have anything to do with your finances. So who should I choose for my healthcare agent? So your healthcare agent can be a family member, it can be a friend, it can be anyone who knows you well and that you trust to make care decisions for you. They must be over the age of 18. They should be willing to fulfill the role as your healthcare agent, able to, and readily available. You don't want to name that person in the family who never answers their phone. Not a good idea. It should be a person who knows your wishes and will follow them, even if they disagree. It's important that this is a person that you've had a conversation with about your wishes. I always encourage people to name a backup agent. For example, sometimes people will name their spouse and then their spouse predeceases them. So if you've named a backup agent, then you'll have someone else in place if your primary agent isn't available or able for some reason. Sometimes people will say, you know, I have 2 children. I'd like to be able to name them jointly so that they can make decisions together. You can do that, but I try to discourage it because it can cause problems because those 2 people will have equal decision-making authority. And sometimes it's very difficult to get people to agree. So if possible, don't name your healthcare agents jointly. Name a primary and a backup or 2. So conversations with your healthcare agent are very important. Having an advance directive does not replace conversation. I can't stress enough the importance of speaking with the person that you're choosing as your healthcare agent, even if you've completed a living will. The more they know, the better they'll be able to advocate for you. And it's not a pleasant conversation to have, but it's certainly an important one. So they'll be able to know what your preferences are if you're facing difficult health decisions, and to make decisions that are consistent with your wishes as much as possible. So sometimes people want to know, well, what if I don't choose a healthcare agent? Or what if I don't have anybody to choose? I don't have any family. I don't really have any close friends. What do I do in that situation? So if you don't have a healthcare agent documented, you will have what's called a surrogate decision maker. And the state assigns a hierarchy to who would fulfill that position, and they're listed here. So first they would look to see if the person has a guardian of person that was assigned by the court. If not, then they look to see if there's a surviving spouse or domestic partner. If not, then they look to see if there are adult children. So no matter how many children you have, if you have 5 children, they all have equal authority. That can be extremely challenging because most times those 5 children aren't going to agree. Everyone has a different idea of what should be done. If you don't have adult children, they'll look to see if you happen to have surviving parents. If not, do you have adult siblings? And if not, are there other relatives or friends? Okay, so now we're going to move on and talk a little bit about the living will portion of the advance directive. This is the part that most people are familiar with when you talk about advance directives. So this is the part that covers your preferences regarding life-sustaining treatments. So things like ventilators, feeding tubes, dialysis, just to name a few. They ask about your preferences regarding life-sustaining treatments in 3 specific situations. The first being a terminal condition that has progressed to the point where death is imminent. The second situation that they ask you to consider is a persistent vegetative state. So this is a situation where you would not be conscious, you're not aware of yourself, your environment, you can't interact with others, and there's no reasonable expectation that you're ever going to regain consciousness. And then the third situation is called an end stage condition. So that's an incurable illness that's progressive. There's nothing that they can do about it. It's expected to continue to get worse and eventually lead to death. And at this point, it's already progressed to where you've lost your mental capacity. You're no longer able to make decisions for yourself, and you become completely physically dependent for all of your needs. So you need help eating, bathing, toileting, dressing, everything. So I always encourage everyone to include a statement of goals and values at end of life. Think about what's important to you. Advanced directives try to make things very black and white, and we all know that there's a whole lot of gray in life. So what can you tell your healthcare agent and your doctor about what's important to you? What should they keep in mind as they're making decisions for you? I'll meet with people who will say, you know, it's important for me to be as pain-free as possible. Other people will say, I just want to be here as long as I can. I want to spend as much time with my family as possible. If I still know who I am, if I can recognize my family, if I'm able to communicate in some way, then let's keep going. And then other people will say, it's all about quality of life to me. But I always tell people, don't just say it's about quality of life, Define that. What does that mean for you? Because it can mean different things to different people. Some people just want to make sure that they can be able to participate in meaningful activities, do something that they enjoy doing. And anything else. It's a very personal thing. It's an optional section in most living wills, but I do strongly encourage people to do that. So definitely something to put some thought into. So what if you don't want to complete a living will? Can I just name a healthcare agent? Yes, but as I've said, please have conversation with that person. Don't assume that they'll know what you want them to do, because that's really not fair. And in a time of crisis, they may forget, even if you've had that conversation. So please try to document your wishes. So there are 3 different types of advance directives. The first type is a written advance directive. There are many different forms out there. Some of the more common ones are the one that's offered by the Maryland Attorney General. It's available on his website. There's also one called 5 Wishes. That's available online as well, although I do believe there's a small fee associated with that one. The one from the Maryland Attorney General's office is free. There's also electronic advance directives, which you all probably already know. You can complete at the speakeasyhoward.org website. They'll have you set up an account. It'll link you with My Directives, so you can complete your advance directive there. There are several advantages to completing your advance directive electronically. The first being, with a written advance directive, you need to have 2 people there to witness your signature. Your healthcare agents can't be witnesses to your signature, and only one of those witnesses can be a family member, as long as you didn't name them as a healthcare agent. Times like these, where we're all trying to physically distance, that can be challenging. An electronic advance directive does not require witnesses to your signature. Another advantage to an electronic advance directive that's completed through My Directives is that once it's completed, it's automatically pulled into a regional information system for patients. So no matter what hospital you may be in the state of Maryland or Washington, D.C., it's going to be accessible to your physicians. They'll be able to see it. You don't have to do anything else. There are also oral advance directives. Those need to be completed with your attending physician and witnessed by a second person. These are typically completed in the hospital as a last resort. Oftentimes this is with a person who is seriously ill. They just do not have the ability to get through an advance directive. Maybe all that they can get out is the name of a person that they want to help with their medical decisions. So it's oftentimes just a healthcare agent. So we try to encourage people not to wait. Do it while you have the capacity to complete an advance directive. Put some thought into your wishes and help your healthcare agent out. Let them know what you want. So some of the key takeaways that I'd like you to think about is just that advance directives, it's about more than just a name on a piece of paper. It's something that should be completed thoughtfully. It needs to be well understood by both you and your healthcare agent, all of your healthcare agents. They do not replace conversations, and they should be completed after conversations if at all possible. And advance directives give peace of mind both to you and to your family because your wishes are known and you know that you'll be well represented by your healthcare agent. I always also encourage people to distribute copies. This is a huge issue that we have at the hospital. We have a person who will come in and they'll say, I have an advance directive. It's in my safe deposit box at the bank. Nobody else can access it. Or my wife can access it, but she doesn't drive anymore, or she's sick also. Make sure your healthcare agents have copies. Make sure your primary care physician has a copy. Make sure there's a copy on file at the hospital. We ask for copies at the hospital because emergencies happen always at the most inopportune times. Even if you have an advance directive and your healthcare agent can access it, do you really want them running around town to the bank to try to get it out of your safe deposit box or to your home to get it out of your files when they'd rather be there with you? The doctor in charge of your care needs to know these are your medical or your healthcare instructions. These are who you want making decisions for you. Your doctor needs to know. They can't assume that. Just because you're married, it doesn't automatically mean that you want your spouse to be making decisions for you. We do have people who choose other family members. Sometimes a person will have an advance directive that they've completed years ago. They can't remember where it is. They don't remember what it says. So it's a good idea to pull those out periodically and review them. Make sure it still reflects your wishes and that you actually know where it is. Sometimes we'll have a person come into the hospital, a family member who thinks that they're the healthcare agent, but they weren't. They were actually named a financial power of attorney or something else, but not the healthcare agent. So it's good to have that documentation in place. Sometimes the document that a person is thinking about isn't actually an advance directive. It might be a general power of attorney or a financial power of attorney, a MOLST form, sometimes an estate will, which deals with your property. Another advantage to bringing it into the hospital is it can be reviewed for completeness. Occasionally someone will provide an advance directive and they think everything's fine, and then we get to looking at it and their witness signature's missing. Maybe it was an advance directive they completed with their attorney, but what they presented to us was just the draft. It's not signed. Sometimes a healthcare agent has been named, only one healthcare agent, and now that person is deceased. So it's a good idea. It gives you a chance to make any corrections that need to be made. Sometimes people will say that their family member knows where it is if it's needed. Make sure they really do. I get phone calls all the time. I know my father has one. I thought it was in his file drawer at his desk and it's not. Did he happen to tell you where it might be? Or they'll say, what is it that I'm looking for? I'm not really sure. What is it? Think about updating your advance directive if you have changes in your medical condition or you need to make changes in your healthcare agent. Do not make corrections on your existing document if it's a paper document. You want to start a new advance directive, and make sure that anyone who holds copies of that older advance directive now has copies of the new one, and destroy the old one. It's no longer valid. So this slide here tells you how you can submit your advance directive to the hospital if you have a written advance directive. This email address is monitored by me, so it's not going to be floating around out there anywhere. It's going to come directly to me. Same thing with this mailing address. It will come directly to me. And my phone number is on here as well if you have any questions. I am in the hospital the majority of the day visiting with patients. So if you call and I don't answer, just please leave a message and I will get back to you as soon as possible. Okay, so I am going to go ahead and turn it over to Alan. I'm trying to, hold on. There we go. Thank you.
Okay, I'm just getting myself together here. I hope I am.
And before you get started, Alan, we just had two questions that I wanted to raise before. So we had people asking if the slides will be available afterwards. So if you both are comfortable with sharing, let me know, and then I can make it available on the website. And then, which is perfect because Alan is about to present, people were asking, what is the difference between a MOLST and an advance directive? So I know Alan is about to answer that now. So I just wanted to raise that before you get started.
Okay, I assume Karen and Rochelle, you can see the presentation.
Yes.
Okay, and actually, one of the things, just by way of background, I'm an attorney. I worked for the Maryland Attorney General's office for 30 years and retired in 2010. And I've really been interested in and feel that it is very important for people to think about, have conversations about, as Karen said, and have documents regarding their preferences for different situations. The thing I think of first is end of life, but as Karen noted, it's if you don't have mental capacity to say yes or no to medical treatment, then someone else has to make that decision for you. And Karen, as Karen noted so clearly, um, that's very, very important because everybody may have different preferences, different things that they think are important. And so it's important to have somebody that you name in advance. I'm sorry, I'm going into your territory, Karen. But so MOLST is related to, but quite different from advanced directives. MOLST is medical orders for life-sustaining treatment. And these are established by Maryland regulations. So this MOLST medical orders for life-sustaining treatment are part of Maryland's system for having documents that express preferences about healthcare under certain circumstances. So it's, and I can't quite, okay. So it's basically in simple terms, and it's complicated. So I consider this to be an introduction. And at the end, you'll see there is a link that you can click on on the internet and find out more information. But it's MOLST is a standardized medical order form. In other words, medical order form is something that a healthcare practitioner, and under Maryland law, it's a physician, um, uh, a nurse practitioner, or and I'm losing the other nurse practitioner and physician, and one other I've forgotten immediately. But they follow a process I'll be going through. And the form is two-sided under Maryland law. It's simple. It's not a wide open form like the advanced directive that Karen was talking about. And these forms, when properly completed and signed by the appropriate medical professional, it lasts forever unless something replaces it. It applies anywhere in Maryland. So it's any healthcare setting. It even applies in the community, meaning, and I'll be talking a little bit about that, but having a MOLST in your house with the information on it that we'll be talking about is what an EMS provider, if they saw that, they would comply with what it says about preferences, about treatment under certain circumstances. And the last point here is, and this is always the case, I think it helps to increase the likelihood that a patient's wishes regarding life-sustaining treatments are honored. And likelihood, and I feel that Karen, in the context in which she works, she has a really good understanding of likelihood, because it's not simply, oh yeah, this is it, that takes care of it. It makes it simple. And the realities of healthcare, as I understand it, I don't have the experience or background. The realities are that things are not simple, and so there's so many different twists and turns. But increasing the likelihood through a MOLST is a good thing. So it's, and now I got it's a physician, nurse practitioner, or physician's assistant under Maryland law can complete and sign this medical order. And that is an order so that other, and I think first of EMS providers, okay, emergency medical service providers, when the ambulance comes to a place, they have to comply with an order by a physician, nurse practitioner, or physician's assistant. This will instruct them on what they have to do. And that's very, very important, because if the proper procedure has been followed in setting that up, then it will increase the likelihood that the patient's preferences will be honored. So and I'll be going through the form briefly. It's very complicated, but you can find it on, well, in some ways it's complicated. You can find it online. So the practitioner, the nurse practitioner, physician, is certifying that when they complete a MOLST, there's been a discussion with and the informed consent, okay, that means the person understands and says yes or no. Patient's healthcare agent, okay, the healthcare agent that that Karen was talking about, that a advance directive can name, a guardian of the person, patient surrogate, that's the person who has the authority for a person that doesn't have the mental ability, and the person who doesn't have the mental ability hasn't filled out an advance directive that names a healthcare agent. And then a minor legal guardian or other legally authorized adult. So so one thing then is the practitioner who fills out the MOLST is saying it's based upon a discussion with and informed consent of, or the practitioner can say the order I'm completing is based on instructions in the patient's advance directive. Okay, and this is the living will part that Karen talked about. That's where it sets out preferences and things that are important to the person. Or, and this is just a general thing, other legal authority in accordance with the Healthcare Decisions Act of Maryland. That's just a very generalized thing. So if a practitioner is talking to a patient or is talking to a healthcare agent, and I'll be going through it, there are situations in which a MOLST must be completed. A MOLST must be completed. That doesn't mean that the patient or the healthcare agent has to discuss the possibilities and all that. They can say, no, I don't want to talk about it, or I just don't know what. Let's take it from a simple standpoint, from the standpoint of the patient who has mental ability. I don't want to talk about it. And you can imagine in our culture, some people, talking about the possibility of death and life-sustaining treatments is too scary, and they don't want to do that. And so some may say no, or some may say, I don't really know what it is I want. Under Maryland regulations, if they say, I don't want to talk about it, or I don't know what I want, then, and you'll see on the form what this is, the front side of the form will be CPR, cardiopulmonary resuscitation, will be attempted regardless. In other words, the default, if the person says, no, I don't want to tell you what I want, or I can't tell you what I want, then it's going to be that there is that it's going to be that it's do everything, is what the MOLST will say on the front side. Now, what I've done is I've got a slide that shows the sides of the Maryland of the MOLST. As I said, it's a 2-page document, and this is very complicated. So more of this, my intention is to have it as more of an introduction so you can see in a general sort of way what's involved. And as I said, the form and other resources is available online, and the link will be at the end of the presentation that I'm giving. But you can see these forms this is mandatory. It's not, like an advanced directive where there can be different things and all that. This form is required as a matter of Maryland law. And so if you look at the upper part, certification for the basis of these orders, now don't forget, this is the healthcare practitioner is saying, they're checking off one of these. This order is the result of a discussion with and the informed consent of, and then it has a list of people. I mean, the simplest thing would be the patient. Okay, the patient, the patient and the healthcare practitioner are having a discussion. Okay, they're talking about the person's particular healthcare needs, the concerns, their preferences, and that back and forth conversation between the physician, the nurse practitioner, or the physician's assistant, that's central, because the discussion helps the patient understand, oh, okay, well, here's what may be happening to me. Here's things of that nature, and this is what's important to me. Hey, nurse practitioner, can you tell me about this, so that they have the best understanding reasonably possible about what is possible for them. And then, as you see on the second part, the order can be based upon instructions in the advance directive, and then other legal authority, which is if Maryland law is changed to allow for other possibilities, that's what that covers. Now, you'll remember that I said, and if you look right above the CPR resuscitation status line there, the very last checkoff in the section above is mark this line if the patient or authorized decision maker declines to discuss or is unable to make a decision about these treatments. So, but you can see, otherwise, if there's no limitations, if they decline to discuss or can't make a decision, then, and you can see the section that has to be filled out under those circumstances right below, CPR status, and it's going to be attempt CPR. So the Maryland regulations have it so that if the patient can't decide or doesn't want to decide, it opts on the side of doing everything to keep them alive, which makes sense in our culture. But that's what the default would be if the person chooses not to or is unable to make decisions about what they would want. So this is still on page 1. This is the bottom of page 1. And so here are the possibilities. You see on the left-hand side, it says 1, okay, in the first page. And so this section covers the different possibilities. And in a simplistic way, I'll say that if you look at the very top, it's attempt CPR, okay? That is, and I'll use, non-medical terms, that essentially means do everything. So you can see it says, if cardiac or pulmonary arrest occurs, attempt cardiopulmonary resuscitation. And this will include any and all medical efforts that are indicated during arrest, including artificial ventilation and efforts to restore or stabilize cardiopulmonary function. Do everything. Then if you look down below, there are 3 more checkoff boxes. So option A1, there are things a little bit less than that, but it's like prior to arrest, administer all medications needed to stabilize. If cardiac or pulmonary, if your heart stops or you stop breathing, don't attempt to bring the person back. Allow death to occur naturally. And there are 2 options for that. Option A1, that may include intubation, that's breathing aid. And but A2, you can do comprehensive efforts to make them comfortable, but no intubation. So these are things, and once again, it's very, very technical. so it's more of an introduction, so you have a sense of what's out there. And then the last one is no CPR, option B, palliative and supportive care. That's basically the patient is saying, and the medical order is ending up saying, I want to be simply kept comfortable. If I'm going to die, then do not attempt resuscitation. And the thing I guess that I think about is when you think about all of the, all of us, all the people that we know, family members of different ages with different healthcare situations, I always like to say that there's no right or wrong, except it's wrong if care doesn't match what the patient wants or would want. That's what's wrong. That's a wrong situation. But a right situation is coming as close as possible to doing, and ideally doing exactly what the person would want. And when Karen talked about, the living will and the conversations with a healthcare agent, the idea is to have information there under these circumstances that will help healthcare providers do as best they can. And so many situations, as Karen said, can be out there, but as best they can to do what the patient would want. Okay, now this is page 2, and under Maryland law, the MOLST is two-sided. So page 1 is the other side, page 2 is the second side. These are things that may apply to certain patients. And I'm not going to go through all the details, but they have different options. So one's artificial ventilation, blood transfusion, hospital transfers, medical workups, that's medical test, receiving antibiotics, okay, receiving antibiotics to quote, cure various diseases. And then artificially administered fluids and nutrition, and dialysis. And so these do not have to, and you'll see under certain circumstances, a MOLST must be completed. The ones on this page 2, the backside, even when a MOLST has to be completed, this does not have to be. And as you might figure, different patients may have different needs and wants and different circumstances, so that for some patients, even when they want to talk about these things, maybe it wouldn't really be, it wouldn't be something that would be of consequence in their lives. You'll notice at the bottom, and this is true on the front page too, signature of physician, nurse practitioner, or physician's assistant. So the signature, their name, their Maryland license number, phone number, the date. And the significant thing is they are required, when I do training for healthcare professionals, for physicians and nurse practitioners, I always say, they're putting their license on the line in a sense, because they have to comply with Maryland law and regulations as they do this. And I think a slide I have later says it, but the thing I've heard about over and over again is that the healthcare, on occasion, physicians have given this form to the patient to complete. Here, fill this out and I'll sign it. That is a violation of Maryland law, and it shouldn't be done that way. So EMS providers, they follow the orders in section 1. That's the front side. Okay, that's all they look at. Okay, remember that's from full code, do full CPR to do nothing. They do not. If they're coming to my house and I have a MOLST on my bed, and they see it, they don't look at the back side. They only look at the front side to see. EMS providers, the ambulance folks, do not follow advanced directives. So the MOLST order is very important. If you don't want CPR in a situation where you may have an emergency. So, so I'm just going to go through these quickly, but section 1 I already talked about. That's the CPR status, and we've already seen that on the form. It's everything from attempt CPR to no CPR, okay? And there are a couple in between ones. Remember, on the back side, artificial ventilation, and it has the different possibilities. And so I'm really repeating the same thing that I showed you on the form earlier on. Blood transfusion. When I think about blood transfusion, one of the things I first think about is those people whose beliefs are that that blood transfusions are wrong or inappropriate, or they don't want them. So that can be a situation where they have that. That could be a situation that's put into a section 3, no blood transfusions. Hospital transfers, medical workup, medical tests. And once again, you can see the range of possibilities in each one. The top possibility is accept any medical test. The bottom possibility is no medical testing for diagnosis or treatment. As you may remember, I said there has to be a discussion between the patient and the healthcare practitioner. So it's important that for that person and what their preferences and what their needs are in their medical situation, for the physician or nurse practitioner or physician assistant to hear what the patient's saying, given their life situation, and to make an order, if appropriate, for the one that fits with what the patient wants. Antibiotics, and you can see it goes everywhere from accept, then to oral only, relief of symptoms only, all the way to the last one, which is no antibiotics at all. Artificial fluids and nutrition, even indefinitely, all the way to no artificial. And some people, and I think Karen talked about this in terms of a living will part. So it's every person has a different perspective on what's important and what they want, given their age, given their health, given so many other factors. And so this, if one of these is chosen during the discussion between the patient and the medical practitioner, it should reflect what the person wants. It should not be what the physician thinks is best. It should be the result of a discussion and then what the patient wants. Dialysis, same thing. Everything from all possibilities except dialysis to no dialysis. And then the last part is the blank space, section 9, other orders. And it can be used to indicate preferences for life-sustaining treatments, chemotherapy, radiation, and it should not be used, as I note here, for things like comfort care. Well, that doesn't mean anything from a medical standpoint. Okay, and as I think I said, if a MOLST has to be completed, section 1 has to be completed for every person, 2 to 9, only if it's appropriate for the person. If the patient changes their mind, then they can change their advance directive and they can ask a nurse or the other healthcare providers to revise their MOLST at any time. Copy's valid. You should make a copy and have it with you so that you can share it with family members and other people. Now, under Maryland law, a MOLST must be completed or an existing one reviewed if the patient's admitted to a nursing home, assisted living, home health agency, hospice, kidney dialysis, and for certain patients, hospitals. As you can imagine, there are an immense number of people who fit these situations: admitting to a nursing home, assisted living, home health, hospice, admitted to a hospital in certain circumstances. So there are lots of situations in which a MOLST must be completed.
Hey, Alan, I'm
Yes.
sorry to interrupt. It is
Yeah.
9:47 though, and you both have 9:45 appointments. So
Oh, okay, fine. Well, then I'm going to stop. And thank you for keeping me from talking too long, Michelle.
You are fine. So I know people had plenty of questions in the chat, so feel free to schedule a one-on-one with Karen or Alan. I am going to really quickly show you guys where you can do that. So if you go to our speakeasyhoward.org website, click here on the Get It Done week, and then scroll to advanced care planning. You can schedule your one-on-one appointment there. And they have times available today. If not, we'll make sure that their information is available for you guys to reach them more directly. And then once Get It Done week is over, we will be able to post the presentations online. Alrighty. So thank you guys so much. I'm sorry to have to cut it a little bit short. There's so much information with both. People had great questions, and I'm sure you'll get more one-on-ones. All right.
Thank you.
Thanks, everybody.